Law.
Hi, thank you. My name is Debbie Taussig. I have a personal injury law firm here in Boulder, and I am going to introduce Joanna briefly to you. She has been my associate attorney for 3 years now. And before that, she was a clerk for Judge McDonald. She has done an extraordinary job and has actually taken over all of the negotiation that we have in our firm. And as you're going to hear from her, negotiation is also the negotiation tactics you can apply in all areas of your life. So I can speak to that. Joanna is very well, she's great at negotiating on her behalf and on behalf of our clients. And I am going to turn it over to her now to talk about negotiating.
Thank you, Debbie, and good afternoon, everyone. My name is Joanna Merrill, and I want to thank you for spending your lunch hour with me. I hope that over the next hour, I can impart to you some of the negotiation skills and tools that I've been able to accumulate as an attorney and just as a regular human person. So I want to get started just really quickly by introducing myself. So again, I'm Joanna Merrill. I'm an associate attorney at Debbie Taussig Law. I got my first taste of legal negotiating in law school at Southwestern Law School in Los Angeles, California, when I was one of a couple dozen selected out of a few hundred to be on the Negotiation Honors Program, which is a competitive negotiating team that competes against schools all over the country. I was a two-time finalist in nationally ranked competitions. And since graduating, I've remained as a part of the program as a coach as well as a competition judge. Then I also completed the Harvard Law School program on negotiation and leadership, which if you are interested in fine-tuning your negotiation skills, getting a lot of real-time practice, I couldn't recommend that program more. As Debbie said, after law school, I was a district court judge for the Honorable Judge McDonald. And I will say I definitely negotiated with him when it came time to deciding how we believed orders should go. We had a lot of conversations that turned into negotiations that always had amicable results. And finally, like Debbie said, as a personal injury attorney here in Boulder, Colorado, I am negotiating daily with insurance adjusters and opposing counsels, trying to get the best results for my clients possible. And I use a lot of the skills that I'm going to teach you today. So enough about me. Actually, that's a lie. A little bit more about me. I was recently married. And I want to kind of bring this into context that while the tools I'm going to teach you today are definitely going to help you in your practices, they're definitely going to help you get better results from your clients, but they're also going to help you outside of your office. They're going to help you negotiate because we're all negotiators all of the time. We negotiate with our spouses for what we want to eat for dinner. We negotiate with our kids to get them to clean their rooms or do their homework. We negotiate with customer service representatives to get discounts on damaged goods. And when I was planning my wedding, I negotiated with dozens and dozens of vendors. So these skills are going to apply in your practice, and they're also going to apply outside of your offices. And as members of the Boulder County Bar Association, we practice all types of law. Most of our days look drastically different from one another's, but what we all have in common is that we are all negotiators. But what is a negotiation, right? A negotiation is just a basic means of getting what you want. It's a back and forth communication just designed to reach an agreement with you and the other side, whom assumingly you have shared interests and also opposing interests. But there's a huge misconception when it comes to negotiations. The misconception is that there should be a winner and a loser, that there are styles and techniques that should be used to best your opponent so you walk away the victor. And I want to forever get rid of that idea if possible, because in my opinion, there should never be a winner in a negotiation. Each side should feel like they're walking away from the negotiation as a winner. And in fact, by the end of the negotiation, in an ideal world, you will be writing your opponent's victory speech and they'll be writing yours. So this type of agreement is called a wise agreement. A wise agreement is defined as one that meets the legitimate interests of each side to the extent possible, resolves conflicting interests fairly, is durable, and takes community interest into account. So how do we achieve this type of wise agreement? We do it by engaging what the Harvard Negotiation Project has defined as a principal negotiation, or a negotiation on the merits. You can learn a lot about this book, as I did, or learn about this topic in the book, Getting to Yes by Roger Fisher and William Ury. A lot of what I'm going to be covering today is a basis of what is the theory that is taught in this book, along with some of my own comments from my own experience. But I can't get through this discussion without giving mad props to this book, because it has definitely encouraged me and assisted me in becoming a better negotiator. So if you haven't read it, I encourage you to do so. So according to the Harvard Negotiation Project, the principal negotiation is a negotiation that's based on the merits rather than the haggling process. It focuses on mutual gains, and when interests conflict, as they do during just about every negotiation, the result is based on some fair standard independent of the will of either side. Now, throughout the book, Getting to Yes and the Harvard Negotiation Project created a 4-step process in method in engaging in principled negotiations. And I'm going to walk you through that 4-step method today. And I want to stop I want to let you know before we get into it that 90% about what I'm going to be talking about today is going to be dealing with preparation and how to prepare your negotiation. Because so often we spend our negotiation preparation time only thinking about our offers. What's our goal? What's our bottom line? What's our starting offer? How much do we want to come down? Are we just going to base it on what the other side says, or do we have a strategy going in? And while that is necessary and necessary part of the process, that's only half the process. And the other half the process is what I'm going to be talking to you today. And a lot of what I'm going to be doing is really just asking you questions of things to be considering while you're going through this process. So, as we go through this project, I'd like for you to consider a negotiation that you're currently engaged in. When I sit through seminars, especially on Zoom, I find them to be the most helpful when I am picturing a case that I am currently working on, and I apply every tool to how I can help this particular client better, rather than it being a more general idea. So if you have that ability, I really encourage you to do so, and I think you'll get a lot more out of this. So, what is the 4-step method for engaging in principled negotiations to achieve a wise agreement? The first step is to separate the people from the problem. The second step is to focus on interests, not positions. The third step is to invent multiple options. And finally, we use objective criteria. So first, we separate the people from the problem, because negotiators are people first, and every negotiator has 2 main interests: substance or outcome, and relationship. So they want to get a good deal and they want to keep an ongoing relationship. Think about a store owner who wants to sell an item for a good price, but he also wants to convert the buyer into a regular customer. To their detriment, most negotiators pit one against each other, which will never end in a wise agreement. Because if you're focused on the relationship, you're going to be willing to pay far more than you should, or get a good deal that's not going to be great for your client. However, if you're so focused on the deal, you're going to do that to the detriment of the relationship. Neither affects a good, wise agreement. So what we need to be doing instead is dealing with each other sensitively as human beings prone to human reactions that can be disastrous or beneficial to a negotiation. So you have to ask yourself continuously, am I paying attention to the people problem? One of the ways to do that is to try to see the problem as the other side sees it. Really empathetically put yourself in their metaphorical shoes and try to understand the point of view from the other side and how they see the problem. You don't have to agree with the other side to understand them. Also, understanding the other side's point of view might help you revise your own view of the problem, and it can help create a more shared interest situation that can lead to better outcomes. And if you don't have a real understanding of what the other side's understanding of the problem is, have a frank discussion with them about it. Ask info gathering questions and actively listen to what they have to say on the other side. And since we all are human beings with emotions, it's important to remember that your opponent has emotions that will influence their position. There's another book I want to bring your attention to, and it's called Beyond Reason, and it's by Roger Fischel and Daniel Shapiro. And in this book, they focus on 5 core concerns that can tend to generate either negative emotions or positive emotions. And if you tend to negative emotions, it tends to have bad outcomes in your negotiation. But if you tend to the positive emotions, you can build rapport and a positive climate for problem-solving negotiations. And within their theory, the 5 core concerns are autonomy, being able to make the decisions on your own, appreciation, feeling appreciation, affiliation, feeling affiliated with the other side and with the community, role, having a role in the negotiation as well as in the outcome, and status. So again, trampling on these emotions can harm a negotiation, while feeding into them and attending to them can really build that rapport needed to engage in a principled negotiation. While you're having these conversations, you need to be actively listening to what the other side has to say. And active listening is more than just hearing the words. It's when the other side speaks, you need to try to understand them as they see themselves. Take in their perceptions, take in their constraints. And I can give you one clue right now. If you are thinking about your response while the other side is speaking, you are not actively listening. But by actively listening, you'll be able to curtail your response to ensure that the other side knows that you understand what they are saying and that they have been heard. Because if the other side doesn't understand, doesn't feel like they're understood, they're going to be thinking about a response to make them feel understood. They're not going to be perceptive to what you have to say. So that's how we separate the people from the problem. Step number 2 is to focus on interests and not positions. So what is a position, first of all, and why is it bad? A position, so positional bargaining, and during positional bargaining, each party takes a side, they argue for it, and they make concessions to reach a compromise. Let's think of this as your traditional haggling on the street. A buyer is interested in buying something that a street vendor has to sell. They each take the position that it should cost a certain price. They'll haggle down, each making concessions until they reach an agreement or the buyer walks away. That is positional bargaining. So basically how that works is one side tells the other side what they want. Think of this as another example, and I'm going to be using these examples throughout my talk today. There's a sister and a brother in a room or in a house, and they each want an orange. And there's only one orange in the house. Each of their positions is, I want one orange. There are 2 people sitting in a room. One person wants the window open. The other person wants the window closed. The positions in this situation are, I want the window open. I want the window closed. In a marriage dissolution proceedings, a position can be, I want $1,000 weekly in maintenance. That is a position. So why are positions bad? Well, when negotiators bargain over positions, then they start to defend them against attack, and then they become committed to these positions. And while they can eventually produce an acceptable agreement, they're not going to meet the criteria of a wise agreement. Because what happens with positional bargaining is it inhibits principled negotiations, because once a person becomes committed to their position, their ego becomes involved. And all of a sudden, their ego becomes a third party in this negotiation that needs to be defended. The negotiator is now no longer focusing on the merits of the negotiation, but on saving face and saving embarrassment and defending their position. They'll never have the ability to engage in a principled negotiation or achieve a wise agreement, because they're never going to dig down deeper. So instead of focusing on positions and letting our positions be the driving force of negotiations, we want to look at interests. Now, what is an interest? An interest is each side's needs, hopes, fears, desires, concerns, etc. Basically, your position is something you have decided upon. Your interests are what is causing you to make that position. So for every position, for every interest, there exist several positions that could satisfy it, opening up the possibility to find alternative positions that suits both your interests and the opposing sides as well. Unfortunately, people tend to find the easiest answer right away, and that easiest answer tends to be relying on their positions. So while we're preparing our offers and while we're preparing our strategy for the negotiation, we would be remiss not to do a deep dive into not only our interests, but the other sides as well. How do we do this? It is very simple by asking one simple one-word question. Why? For each position you take or the other side takes, ask why. Ask your opponent why they are taking the position, but not just for the purpose of justifying your position over theirs, but to actually understand the other side's needs, fears, hopes, desires that their position serves. What concern do you have about keeping the window open? Why are you concerned about this? Another way is simply to ask why not. Why do you not want to make this decision? What interests of yours are standing in your way from saying yes? Why is it that you don't want the window open? These are the questions that we ask ourselves and our opponents, and maybe we ask ourselves as our opponents, trying to really understand the underlying interests that are creating the problem that needs to be solved in the negotiation. So as examples from before, the example of the brother and the sister, I want an orange. Well, the sister asks the brother, why do you want the orange? And he says, well, I'm very thirsty and I want some orange juice. So I want to squeeze out all the juice. And the brother says, sister, why do you want the orange? And the sister says, well, I'm trying to bake a cake and the recipe calls for the zest of an entire orange. So simply by asking one word question, each side has a far better understanding of the scope of possible positions that satisfy each of their independent interests. Again, with the window open and closing example, one person asks the other person, why do they want the window open? They say, well, it's stuffy in here. And they say, why do you not want the window open? And they say, well, I don't like a draft on me. Again, while we can have a wide range of positions that can satisfy each of their independent interests. If one note, if you are negotiating against multiple opponents that are all on the same side, even though they're on the same side, they still might have opposing interests. So you want to make sure that you're doing an evaluation of the interests of each party in an agreement, even if they're on the same side or not. One helpful way to discover the other side's interests without asking, and this is my favorite tactic, is to role play your negotiation. So get a colleague, get a friend, get an associate, get a paralegal to sit with you and play you while you fill in the role of the other side, and you come up with their entire strategy, their offers, their interests, and you actually role play through the entire negotiation. And I'm telling you, not only are you going to find out ways and be more empathetic to the other side, but you're also going to find ways to defeat your own case. So in a very similar way to the way that in our practice, we use focus groups to discover holes in our case, doing practice role-playing negotiations can help you find the holes in yours. So I can't encourage those enough. And you need to also make sure that you're communicating your interests to the other side. So you want to be specific, use facts, because the goal is to be credible. You want them to feel like you're not attacking them personally, but rather that you're creating a problem that legitimately demands their attention. And you also want to acknowledge the other side's interests, because people listen better when they feel understood. So if you want the other side to appreciate your interests, you have to demonstrate that you understand and appreciate theirs. And it's simple by saying, I understand that your interests are X, Y, and Z. Have I understood you correctly? Did I miss anything? And then also acknowledge that their interests are a part of the problem that we all need to collectively work together to solve. And then finally, highlight shared interests, because this builds rapport and creates more of a partnership than a win or loss situation. Once you've discovered your interests, you go to the negotiation with a couple different options that you think can suit each side's interests and go in with an open mind. So finally, attack the problem without blaming the people. Give positive support to the human beings on the other side with the same strength and vigor that you're going to emphasize the problem. The problem is that we only have one orange. It's not because you as the other person wants the orange I have. The problem is the lack of oranges. So let's make sure we keep our focus that way. So step 3, invent options for mutual gain. So a negotiator who is very well practiced is usually going to have the skills to invent solutions advantageous to both sides. They expand the pie before they divide it. And this is just a skill that requires practice. It requires a lot of negotiations to be able to creatively come up with options that are not very obvious. And by failing to take time in your negotiation prep, as well as your negotiation, to invent additional options, you risk leaving money on the table by either failing to reach an agreement or by reaching an agreement that actually could have been better. So without taking time to invent options, we're going to default to the easiest option, which typically is not the best. On the outset on a negotiation, typically all options seem available are on one straight line in between you and your opponent, in between your positions, in between each of your positions. However, with creative and innovative thinking, there could be an entire spectrum of possible agreements. And this spectrum is called the zone of potential agreement, or also known as the ZOPA. The ZOPA, the zone of potential agreement, is where the terms that both parties are willing to agree to overlap. And if there is a resolution that both parties would prefer over their own bottom lines, then a ZOPA exists, and it would be in both parties' best interest to reach an agreement. And then it's in each negotiator's best interest to explore all the possibilities of what a ZOPA could be, where that zone of interest colliding are there in the negotiation. And also realize that the ZOPA is fluid and can change throughout the negotiation, depending on what concessions are made. I want to give you an example of this. In a dissolution of marriage proceeding, a husband may really want a painting that right now is off the table for him to obtain. However, if he agrees to other conditions, such as a more favorable custody agreement for the wife, or agrees to do something like give the house to the wife, maybe that painting can be back on the table based on the concessions he's made. So again, even through that negotiation process, the ZOPA, the zone of potential agreement, was fluid and changed based on agreements and concessions made throughout the negotiation. So during your preparation, you need to consider about what the potential ZOPA could be. Design different offers that could potentially fit within that ZOPA. What do you think is the highest the other side is willing to go to? Compare that with the lowest you are willing to go. What agreements could possibly fit within that space? I mentioned role-playing earlier that role-playing is helpful in discovering your other side's interests. It's also really helpful in discovering a potential ZOPAs as well. And then you really want to go to the table knowing what your ZOPA is, or at least by using your intuition and knowledge of the issue to have a good estimate of what you think is the zone of potential agreement. So Dr. Fisher, in the book Getting to Yes, I'm going to go back to that, has identified 4 major obstacles that inhibit the inventing an abundance of options. So the first is making a premature judgment or criticism, which doing this stifles creativity and hinders imagination. And this could be judging your opponent as more or less powerful, judging the problem as more or less fixable, or judging the result as more or less possible. All of these judgments get into your headspace and make creative and innovative thinking less possible. Also, searching for the single answer. By looking for one single best answer, you're likely to miss a wiser decision-making process in which you select from a large number of possible answers. There's the assumption of a fixed pie. Each side goes into the negotiation seeing it as an either-or situation, or win-or-loss situation. We often approach negotiations with the assumption of a pie of resources that's fixed, a mindset that leads us to interpret most competitive sources as merely win or lose. Harvard Business School professor Max Bazerman has kind of worked through this theory, and his argument is that negotiators fall victim to the fixed pie mindset when they fail to recognize that they have the ability to make trade-offs across issues. That is, one party can compromise on an issue she values less in exchange for a concession from the other party that she values more. Finally, the other obstacle is assuming that the other side's problem is their problem. To reach an agreement that meets your own self-interest, you need to develop a solution that also appeals to the other side's interests as well. So how do we overcome these obstacles? Well, first, to overcome premature judgment, we want to separate the act of inventing options from the act of deciding them. And by doing this, the best way is to form brainstorming sessions. During these sessions, you want to produce as many ideas as possible that can help solve your interests as well as your other sides. And the rule for these sessions is that you have to postpone all criticisms until after it's over, because you want to just give us the space for creative thought and innovation and freedom, and that can all be stifled if you're starting off every option with a criticism of why it's not a good option. So save your criticisms for the end and list off all the different types of offers that you can make, or all the different types of concessions, all the different types of agreements. Broaden the scope of the ZOPA. Let's see. Okay, so then the next thing is you want to broaden the options on the table rather than looking for a single answer. So the more solutions that are on the table, the higher the potential to coming to a wise agreement. So these is what you get from your brainstorming sessions. Another way to think of and create options is a four-step process. So think about a particular problem. You diagnose the particular problem from your point of view, from the other side's of view. Think about how an expert would diagnose this problem. For instance, if there's mold in a house, how would you diagnose the problem? How would an expert, how would a home builder, a contractor, how would they diagnose the problem? Then prescribe the problem. How do we fix the problem? And again, from each point of view that you use to diagnose the problem, you want to have a prescription from each of those points of view as well. Then consider what ought to possibly be done. Or from what you decided ought to be done, then you come up with specific and feasible solutions for action. So all of those possibilities, out of all of those possible fix-its and prescriptions, what are actually feasible and can be put into action now? One way to broaden the options is to change the scope of a proposed agreement, because agreements may be partial, they may involve fewer parties, they may cover only selective subject matters, they can only agree to certain geographical areas, or they can remain effective in shorter periods of time. So rather than seeing the agreement as all or nothing, consider, can this agreement be fragmented to make a better outcome? So the next step to overcoming obstacles is to search for mutual gains. Because it's a myth that in negotiations, there is a fixed pie. The less for you, the more for me. So to do this, we want to identify shared interests, because shared interests tend to lay latent during most negotiations. So we have to ask ourselves, what opportunities lie ahead for mutual benefit? And are there common principles and interests that we can both respect? Make the shared interest explicit and formulate it as a real goal. Make the interest concrete and future-oriented. And then stressing shared interests can make the negotiation smoother and more amicable and collaborative. However, we also have to identify differing interests, because often wise agreements are reached because each side wants different things. I want you to consider this poem. Jack Sprat could eat no fat, his wife could eat no lean. And so betwixt them both, they licked their platter clean. What are the shared interests in this poem? Having a nice meal, sharing a plate to save costs in this economy, eating enough to feel full and satisfied and happy, maybe sharing a special moment together. Where are their differing interests? Well, clearly, Jack Sprat doesn't like eating fat, and his wife doesn't like eating lean. So by focusing on these shared interests and also their differing interests, they can realize that by sharing a plate of somewhat fatty, somewhat lean meat, they can have a great deal and a great meal. I want to share this slide. I'm not really going to discuss it in too much detail, but it's really just common variations of interest to consider when you're doing all of this planning, different areas. So take this list if you want and see where in this do you, with your opponent, do you have shared interests, and where in this do you have differing interests? Because by, again, finding interests that are less important to you and more important to the other party can allow you to make a concession that costs you nothing while allowing you to get something out of the deal that means much more to you and your clients. So the final step to overcoming and inhibiting obstacles is to invent ways of making their decision easy. And we do this by putting ourselves in the other side's shoes. Think about what their interests are, what problems do they need to have solved, and what solutions can you come up with that solve their problems while also meeting your interests at the same time? What solutions can you come up with that solve your problems while also meeting theirs? What does the other side have at stake? And how will the other side be criticized if they took your offer? Or in the alternative, how will the other side be criticized if they fail to come to a deal today? I want to go back to the mold example because this is actually a real life example that just happened with my brother-in-law who had mold in his apartment, and he had written a letter that he wanted to send to his landlord that had done all the legal research. He had cited the part in the contract that the mold was in violation of. He'd talked about the warranty of habitability and all the things that from a legal standpoint we would find necessary. He also talked about all the ways that the mold affected him and how it was going to cause him health issues and how he's not going to feel safe in his home and all of these things. And when I read the letter, I realized that there was one key issue missing in it to be an effective negotiative tool. And that was he failed to discuss the other side's, the landlord's interests at all. So I asked him, what would make it easy for the other side to walk away? What would make his decision so easy? Why does he want out of this contract? And the ideas we came up with is one, it's a lot cheaper. It would be a lot easier to mitigate the mold situation if he wasn't living there. And it would be a lot cheaper for him to mitigate the mold situation without having to rehouse my brother-in-law and have to restore all of his belongings. Further, we realized that the apartment is in a killer location and could easily be sold for a higher rate once the mold is mitigated and the house is cleaned up a little bit. All of these steps would be easier to do if my brother-in-law wasn't living at the house at the time. And so it was in both sides' best interest to walk away. And I can tell you, he sent the letter and he told me the next day that the landlord had rescinded the contract. The fourth step is to use objective criteria. Because deciding on the basis of will is costly. The negotiation should not be centered around what each side is willing and unwilling to accept, because then you create a situation where you pit one will against the other sides, and either you have to back down or they do. And that is not a collaborative principled negotiation style. So first we have to determine the objective criteria. And this could be objective safety standards, standards of fairness, efficiency, scientific merit, or that bear on the weight of precedent and court decisions. And why is this important? Because if an agreement lacks standard terms or conforms to practices in the industry, there is a huge risk that one negotiator may feel slighted by the end of the deal. So in principled negotiations based on objective criteria prevents the constant battle for dominance. So one thing we need to do is we need to think of these standards beforehand. They must be independent of the will of either side, and they must be legitimate and practical. One way to ensure this is to use the test of reciprocal application to tell you whether your proposed criterion is fair and independent of the will of either side. An example of this is a home buyer asks a seller, real estate agent who hands them a contract, if you were buying a house, would you use this exact same contract? Or what changes would you insist on making in order to enter this contract? I have a slide here. This is a list of fair standards. If you want to take another screenshot or whatever, this is just different types of standards that you can think about explore while you're trying to come up with what you want to rely on or what the other side may agree to. The procedures need to be fair in order to, you should rely on fair procedures. Oh, sorry. Another option is creating fair procedures when you're trying to resolve conflicting interests. Basically, you want to find a procedural issue to the solution. The easiest way that I'm sure most of us have all heard is when two children are trying to share a piece of cake, one slices, the other chooses. So basically, these are basic means of settling differences. Taking turns, drawing lots, or letting someone else decide are all procedural solutions to conflicting interests. You want to not use objective standards and precedent only as arguments in support of a position based solely on the criteria that you're putting forth. So what the other side deems fair and objective criteria may not sound fair to you, just like the criteria you're selecting may not sound fair to them. So it's best to come with a couple of different criteria that you're satisfied with using and giving them the option, giving them a role in the negotiation, which tends to their emotion needs, and also giving them autonomy for being a part of making the decision. You want to ask, and if the other side comes with a conclusion based on their own criteria, let's ask about it. Ask how they came to their conclusion. How did you arrive at your figure? What standard did you use to determine that amount? When each party puts forth a standard, use the objective criteria for determining the standard to apply. Test out the various standards to see which results in most fair and agreeable outcomes. So shift this conversation from what the other side is willing to do to the question of how the matter ought to be decided. Now we've made it through the 4 steps of the negotiation process. Now I want to talk about the 4 steps of engaging in a principled negotiation to achieve a wise agreement. Now I want to talk about balancing power, because no matter what negotiation you come to, there's always going to be some sort of power imbalance. And I want to start by cautioning you to be aware of your bottom line. And I know I said bottom line earlier, but I really said that for context because now I want to get rid of the idea of the bottom line. There is a benefit to a bottom line. It makes it easier to resist pressure and temptations of the moment, which saves you from making a decision you might later forget. It keeps you from making an impulse buy based on your emotionality in the moment. However, by definition, a bottom line is a position that is not to be changed. And thereby, bottom lines inhibit imagination. So while adopting a bottom line might protect you from adopting a very bad agreement, it can also keep you from both inventing and from agreeing to a solution that would be wise for you to accept. So what do we use instead of a bottom line? We use our BATNA, the best alternative to a negotiated agreement. The BATNA is the course of action you would take if you do not reach an agreement in the current negotiation. Your BATNA is the only standard that can protect you from both either accepting terms that are too unfavorable or from rejecting terms that would be in your interest to accept. So first we need to find our BATNA, the best alternative to a negotiated agreement. We do this by thinking, what are the alternatives if an agreement is not reached? Which of those alternatives is most attractive to us? Then we weigh our BATNA. How does that alternative compare to the other side's best offer? So in my practice in personal injury litigation, our BATNA is typically filing a lawsuit. So when I'm weighing an insurance adjuster's best offer against my BATNA of filing a lawsuit, I have to think about what are the risks and benefits of filing a lawsuit? What are the risks to my client? What are the risks to my firm? What are the benefits to both parties? I have to think about all of those things before determining whether whether I should advise my client that this is an offer worth accepting or not. Too often, negotiators fail to consider their BATNA, and instead they go to the table with a let's negotiate and see what happens type of mentality. And this can create lots of issues because on one hand, they might be taking too rosy view of the consequences of not reaching an agreement. Thinking of, an example of this is someone going off for a job interview, thinking, well, if I don't get this job, I'll get another job, without actually taking stock of what job opportunities are available. On the other hand, you might be too pessimistic of what would happen if you fail to reach an agreement, making you desperate to make this agreement and do whatever it takes and make any concessions it takes to make this agreement. On either way, you're not going to achieve a wise agreement because you're not taking stock of what your BATNA really is. You want to prepare your BATNA long before you sit at a negotiation table. You want to vigorously explore what would happen if you do not reach an agreement. A quick steps to inventing a BATNA: you want to invent a list of actions you might take if no action is reached, improve of some of the more promising ideas and convert them into actual practical alternatives. So if you're thinking about getting another job and you think it's so easy to find another job, take stock of the job market, apply to other jobs, see if you can get a job before you go to this interview you really want. Then you tentatively accept the best alternative that you've created. Another step with this is you want to create a tripwire plan, which is similar to a BATNA, except it gives you room to move. So it's an outcome that's far from perfect, but it's still better than your BATNA, where you still have room to move. And when an offer is similar to that, basically tripping your wire, that's when you know you need to slow down. You need to pause and you need to think. You need to think what other concessions can I make to get more of what I want? Should I be making any more concessions? Are there other creative ways to think about this problem? Or how seriously should I be considering my BATNA? And during that time, you slow down, you take a break, you really want to consider and carefully plan out your next offers, because you're reaching your BATNA and it's almost time to walk away from the table. What does your BATNA have to do with balancing power? Well, the better your alternative is to making an agreement, the better the power you're going to have, because the relative power of two parties depends upon how attractive it is to each party to not reach an agreement. And the inverse, basically the relative negotiating power is determined by each side's best alternative. Think about it this way. There's two tourists in Mexico and they both want to buy a silver ring. And they both have equal wealth. The first goes to the first store they find and they start demanding prices, thinking that the inequality between their wealth and the store owners is going to give them power. Well, they fail to consider that the store owner has the experience to estimate when and for how much she will be able to resell this ring to someone else. The tourist, on the other hand, does not know how much it would cost or how difficult it would be to find a comparable ring. If he walks away, there's a huge risk that he's not going to be able to find a comparable ring for a comparable price. Now, if we think about the second tourist who spent their entire trip walking around to all the different jewelry stores, they had conversations with vendors and store owners and employees and looked at hundreds of rings. By the time they choose to try to enter negotiation to buy a ring, they are going to know how hard it would be to find another comparable ring or what comparable rings would cost. And in the end, the tourist's wealth had nothing to do with their power. Another example of this is going back to the job interview. I'm hoping all of you have had the chance of walking into a job interview already having an offer. How does that change your mindset and your confidence in the negotiating power of you getting this job? Think about that. Knowing what you are going to do if the negotiation does not lead to an agreement will give you additional confidence in the negotiating process. The greater your willingness is to break off negotiations, the more forcefully you can present your own interests and the interests of your clients. So this is basically where I'm ending my talk about coming from with Roger Fisher, because while getting to yes and all of the advice he gives in this book are great tools that I can't recommend enough, they are just one tool that I hope you are going to bring to your next negotiation amongst many other tools you wear on your negotiating belt. Because as we know, not every negotiation is going to be collaborative. And there are a vast array of negotiating tools that you should have on your belt when, just in case the negotiation turns south. Because what happens if your opponent is adversarial, unprepared, focused on that linear line between positions and not willing to see the ZOPA or to open up to this zone of possible alternatives? What if they're not willing to collaborate? Or if they're not willing to agree to any objective standard, much less one you're presenting? And what if they're not a very good negotiator? And as we always know, with every negotiation, there's always going to be a surprise. No matter how much due diligence you do, at some point along the line, you will be surprised by something. So in that time, we need to be able to rely upon our tools. And I want to go through some of those tools right now. So how do we overcome our opponent's scorched earth tactics? Well, one, we ask questions. We disarm them by asking questions. We make them do all of that preparation work that we've already done. We make them do it at the table. And we channel into seeking out their interests. How did you come to your offer? What criteria are you using? What are your concerns with my offer? What are your concerns with my criteria? Seek out and discuss the underlying interests or the interests underlying each other side's positions and really do the work there. You want to anchor the negotiation and you're off by using offers with justifications. There's a lot of controversy, and I'm sure you've heard it if you've been negotiating for a long time, of whether you lose power by making the first offer. And I think in some situations you do. My practice is if you think that they're going to lowball you, then it's necessary that you make the first offer because you want to anchor the negotiation in your best interests. Now, if you do think or have an inclination that they're going to give you a much higher offer than that, maybe you do let them anchor the offer higher. However, in an adversarial negotiation, like one I face a lot with insurance companies, I know that they're going to typically give lower offers. And so I like to start my negotiations by anchoring it up high. If you're in the middle of a negotiation, you can always try and re-anchor by using offers by maybe offering a little bit less or really just planning your strategy in order to anchor it to a result that is more in your best interest. But I want to warn you that with every offer you give, you have to back it up with a real justification. This is not a time for BS or you lose your credibility at the table. Another way to overcome your opponent's scorched earth tactics is to create package offers that address both sides' interests. Because frankly, your opponent is probably going to the easy single solution that we talked about earlier, which is inhibiting their ability to come up with creative alternatives. So by creating a package offer that addresses both sides' interests and brings in that creativity, you might be opening their mind for the first time to the wide range of solutions that could be reached. So sometimes, again, it's you having to do the work for the other side. Another option, especially if it gets heated or really adversarial, is to use de-escalation techniques. But also, again, focus on the 5 core concerns that I spoke about earlier that it's discussed in Beyond Reason: autonomy, appreciation, affiliation, role, status. Tend to all of those emotions and to try to calm the situation down and get back to a collaborative position. Take breaks. If you feel the negotiation is getting heated, you feel it's moving too fast, you feel like it's getting adversarial, you should feel empowered to take a 5-minute break, to take a week-long break, go into another room for a few minutes, because this will not only let the situation calm down, but it'll disrupt the process and the pace of the mediation to hopefully you can reclaim some of that control and some of that power back. I also want to encourage the power of the pause. And this is just while you're engaged in the negotiation, while you're talking. Don't always feel compelled to speak and to respond immediately all the time. If you're given an offer, if you're given a piece of information to consider, take a pause, take time, consider it. creative thinking often doesn't happen right away, and it often takes moments to think about it and be thoughtful. And this gives you the added benefit because as humans, we are uncomfortable in silence, and people will often try and fill silence with words. So if you're taking a moment of silence to get your thoughts together, to change the pace of the negotiation, to consider an offer, whatever it is, the other side may be just more compelled to talk and to keep talking and to keep talking and giving. In the meantime, you're just collecting valuable information that you can then use moving forward in the negotiation. So don't ever be afraid of silence. And if the other side is taking a pause, don't feel the need to fill that silence and thereby giving information that you might want to keep hold of until later in the negotiation. And finally, I want you to be flexible and confident because you've done all the work. You've taken the time. You've done, you know your position, you know your interests. Hopefully you have a good idea of the other side's interests, and you're prepared to do this negotiation. So if things are going awry and things are getting adversarial and heated, it's time to lean back on your intelligence, on your confidence, on the fact that you know what you're doing. Before my very first negotiation competition, I was a little nervous, and I was talking to my mom, and we came up with an affirmation, and I want to impart that affirmation with you today because it is the same affirmation that I use every day before I go into any negotiation. Calm, confident, control. Control over myself, control over my emotions, control over the table. That's my affirmation. Calm, confident, control. So I'm going to end today by giving you this list of helpful negotiation phrases that I use, that some of my colleagues that I've reached out to like to use. These are just ways to either kind of take power back, to make situations more collaborative, or just to give praise. I think that these are just a really great list of just helpful phrases that you can hopefully use in your practice. So I'm going to leave this up, but my final thoughts is that by using the 4-step method in engaging principal negotiations, you will be able to avoid the risks of accepting terms that may be too unfavorable to your clients or rejecting terms that would be in your best interest to accept. It'll help you create collaborative negotiations, and I hope in the end of the day, it'll give you a little bit of fun. So, and the last thing I have to say is that if you can, consider your negotiation opponent a partner rather than an opponent, because that's going to change your mindset from the outset. And I know this is not going to be possible in every negotiation and in every situation. However, the more you can consider your opponent to be your partner, the more you're going to be walking to the table, ready to collaborate, to work together, to problem solve, and to come up with a wise agreement. Thank you, Boulder County Bar Association, for having me today. I hope that you enjoyed this talk. And if anyone has any questions, we have about 6 minutes, and I'm happy to answer anything. I guess I should open up the screen. Hey, Kyle, are you there? Do you know if there are any questions?
I don't see any in the chat. Again, everyone who's on listening, if you'd like to send a message, you can now unmute yourselves if you have a direct question for Joanna. I didn't see any pop in during the chat. Oh, let's see what this is. Will you please send the slides? So Joanna, you had sent me those slides the other day. So after the CLE ends, I'll send the CLE form and the slides. I'll also get the recording of this program up by this afternoon, and I'll send it to anyone. So if you were late or if there were any issues you wanted to go back and revisit, you're welcome to. Okay, from Heather Rutherford, Joanna, most DR mediations are shuttle style. Any tips for that style of negotiation?
Not sure what shuttle style means. Heather, could you please give, or if you want to speak up and just give me a quick definition of shuttle style? Or if somebody else knows.
One new message. Heather wrote, shuttle equals mediator goes back and forth.
Oh, yes. So, I mean, I think it's going to be, what I would say is if you are noticing that you're hearing a lot of positions, a lot of I wants, ask your mediator to be the person asking questions. So maybe send him back not with another offer, but with a list of questions, him or her, I should say, that's not right. Him or her, a list of questions that he could go ask the other side to really do the digging into the interest to get you the information that you want.
Seems like a good answer. Again, it's a great idea. Thank you from Heather. And if anyone has a question that occurs to them later, I'm happy to, if you want to send it to me, I can make sure Joanna gets it and gets in touch with you about it. We'll give it another 30 seconds or so, but otherwise, again, thank you, Joanna, for presenting today. Thank you to Debbie Taussig for introducing, and I'll get the slide, CLE form, and recording link out to everyone promptly. But I think we'll probably call it because I don't see anything else coming in.
Sounds good.
There are lots of great presentations, and thank you for presenting from the group. So let me pass those along, Joanna. Thank you. And yes, this was fantastic, and this will be a great resource to have on our website moving forward. So yeah, that's it. Thanks, Joanna, again,
everyone.
and thank you everyone for joining us. And I'll get that information out this afternoon. Bye, everyone.
Goodbye. Thank you.
Bye.